This courtroom video captures two unforgettable clashes between sovereign citizens and the legal system, showing just how quickly small cases can spiral out of control. In the first case, a man shows up over a simple parking ticket, something that normally would take just minutes. But instead of following the rules, he repeatedly calls the judge by his first name, Andrew, interrupts constantly, and refuses to listen to warnings. His behavior frustrates the courtroom, and what should have been a minor issue turns serious. The judge finally holds him in direct contempt, and he ends up spending a day in jail. A simple ticket suddenly becomes a costly lesson in respecting the law. The second case involves a woman being sued for a $643.63 credit card debt. She tries a very unconventional defense, claiming that credit cards aren't real money, and insisting she needs to see the original contract with the bank to prove the debt was legally sold. She even files a counterclaim seeking thousands of dollars for her time spent on the lawsuit. Despite her arguments, the judge points out that she had already made payments to the company and ultimately dismisses her counterclaim, ruling in favor of the creditor for the full amount. Two defendants, two bold and unusual strategies, and two clear lessons. Ignoring courtroom rules and relying on unconventional legal theories rarely work. This video is a dramatic reminder of how quickly courtroom proceedings can escalate when people challenge authority in unexpected ways.
It was $400 for the tether just to buy it, and it was $300 for a month just to get it.
The last thing I want to do is put you in jail because you're causing an upset to the court.
I agree. Preston, I agree with that. What up, man?
I need you to relax.
Thank you. I'm cool.
You're here to review. Yeah,
I'm here to
Mr.
Finley.
Mr. Finley, you have to stop. You have to stop. So review to get you back on the right track.
Right, but here's another thing, and here's another thing, and when we need people to, if you gave me time, that would be like giving someone time for a parking violation. It don't make sense, Andrew. You smart, man.
That's not how this works. I'm gonna give you a chance to relax.
Right. Just stand here and let's do the review.
Mr. Young?
I'm still recording. And you can read it all the statutes you want. If it doesn't make sense, it doesn't make sense, Andrew.
Mr. Finley, I have to hold you in direct contempt for continuing to interrupt the court. You're sentenced to a day in jail.
Oh
my God.
Morning, Your Honor. Elizabeth Smith, P63010, appearing on behalf of Midland.
Plaintiff, please state your name for the record.
Rachel Langoni.
Your volume is a little low.
Okay. Is that any better?
That's better. Okay, so today was the date that was scheduled for a motion for summary disposition that was filed by Midland. They're asking for the court to strike, excuse me, the defendant's answer and dismiss the counterclaim, saying that the counterclaim doesn't seek relief that the court could grant.
She is seeking dismissal of the claims against her and asking for an award of $3,744. It does not go into any detail about anything my client would have done wrong. So there's really no basis on which to grant any sort of relief as to the counterclaim. As for our motion for summary disposition, reviewing the defendant's pleadings filed, the crux of the matter is she doesn't believe that she owes anything to Midland because the original creditor was a different entity. So it was a Children's Place credit card held through Comenity Bank. The account was used. We attached about a year and a half worth of billing statements to our motion showing use, purchases and payments on the subject account. in December of 2021. The account was charged off and sold to Midland. Also, as part of our documents is a letter sent by Comenity to Ms. Langoni explaining that the account with Comenity has been charged off. It was purchased by Midland Credit Management. Any further communications and or payments were to be made with Midland Credit Management. Ms. Langoni did in fact contact Midland and set up a payment plan. The payment plan was ultimately defaulted with only 1 or 2 payments having been applied to the account. So there's just really no issue left to resolve. Midland owns the account. The balance due and owing, there's no dispute as to that. There's no dispute that Ms. Langoni had the original card. The only issue is her belief that she doesn't have to pay Midland. And again, based on the proofs provided by Midland, and the fact that there was in fact a payment plan set up with Midland, I'll point to the fact that Midland does in fact own the account, is permitted to collect on same. And so we're asking that Your Honor please dismiss the counterclaim for the reasons previously stated, and then also grant summary disposition on Midland's claim, as there really is no underlying issue for trial.
Response to the plaintiff counter defendant's motion review.
No, and I did try to contact legal aid and get some advice. The only thing that she told me that I could do was to ask you to amend my response. As far as what she sent, I still, when we were here the last time and I met with counsel in a separate room, I still maintain that I would like to see the contract. Whether that's, I mean, especially between myself and Comenity, to see that they were legally able to sell the debt. Because if I could go to trial, I would show that the chances that the Comenity was paid for the debt. And I want to be able to show that. It's very different, because if I were to go to court with Comenity, that would have to go through a federal court. It's very different than saying that
let me get some clarity here. You're not disputing that you had a Children's Place account, correct?
Correct.
You're disputing, and you're not disputing that there was a balance of $643.63?
No, I'm not disputing that.
Okay, your dispute is that you have paid that $643.63? It
was paid when I opened the account.
It was paid by who?
The process, and this is why I wanted to go to trial, because there's so much to explain.
Your Honor, if I may, I believe this is, we've seen this going around online. It basically comes down to an argument that credit cards aren't real money, and somehow by opening a credit card, Comenity is really doing some other sort of banking thing, and it's not really money that has to be paid back. You have to let her give her response, because she's not actually drafted a motion or a responsive motion to you. And then I'll let you respond to what she's saying, but she's got to have an opportunity to make her statements as to what she believes her defense is. Sure.
So you're saying you didn't pay, you charged $643.63 on the Children's Place card, but you didn't pay for it?
I did pay on it at the time, because I didn't realize what had happened. And when this all started, when I started questioning what was going on, I had called Comenity.
What do you mean what was going on? I don't know what that means.
When I was trying to understand the legalities of a contract and how the banking system works, I was just studying this on my own. And so I had called Comenity a couple times, spoke to 2 different people, and all I did was I wanted the original contract so that I could learn the legal terms, how it works, the process. And when they kept telling me that they didn't have this contract, that's when I started asking more questions and learning how important contract law is, and the fact that it's somehow magically disappeared. I don't understand why the most important legally binding contract would have just magically disappeared. So I started asking a lot of questions, and what I'm basing it off of is off of federal regulations, federal codes, the UCC 3. It's not what the attorney just made it out to be, but it is a lot to explain, and I'm still learning. But
Okay.
I do want to maintain my right to defend myself against.
That your right to defend yourself starts with the summary disposition. You don't just get to skip over that portion. If there is a motion for summary disposition, they're saying that you don't have a valid defense, that you have not presented an issue of genuine dispute. You need to now plead to me something that makes me believe that there is an issue of genuine fact that needs to be resolved by either a jury or a trier of fact. And you've not yet provided me that. That's why it was important for you to respond in writing to their motion. I'm giving you an opportunity now to respond verbally, but I need to hear some information that would allow me to understand your mindset and why you believe that you can open a credit card and then charge a balance and then not have to pay the balance.
Right, and that's
So answer that.
it is very difficult.
Courtrooms are usually places where rules are followed, where decorum is expected, and where small disputes are handled in a calm, procedural manner. But sometimes, even the simplest cases can explode into chaos when people decide that the law doesn't apply to them. This video captures two of the most extreme examples of that kind of behavior. Two cases involving individuals who identify as sovereign citizens, people who believe they are not bound by standard legal rules. What unfolds in these hearings is both shocking and strangely fascinating, showing just how quickly routine legal proceedings can spiral out of control. In the first case, a man appears in court over what should have been a minor parking ticket. Normally, this kind of case is straightforward. A person either pays the fine, contests it politely, or presents a simple defense. But this man takes a very different approach. From the moment he steps into the courtroom, he challenges the authority of the judge in an incredibly unusual way. He begins to address the judge by his first name, Andrew, repeatedly ignoring the formalities and expectations of a courtroom. The judge, maintaining patience at first, reminds him that proper etiquette is required, that he must follow the rules, and that his behavior is inappropriate. Despite these repeated warnings, the man continues. He interrupts constantly, talks over the judge, and acts as if the warnings don't apply to him. Each time the judge tries to regain control, the man escalates the situation further. His behavior is frustrating, confusing, and at times, almost comical, but it also highlights a deeper issue, a complete lack of understanding or respect for the way courts operate. What might have been a quick in-and-out resolution for a parking ticket instead becomes a test of authority and patience. The courtroom grows tense, and the atmosphere shifts from routine to confrontational. Finally, the judge has no choice but to take action. He holds the man in direct contempt of court. The consequences are immediate: a day in jail, a single parking ticket, transformed into a night behind bars, all because of repeated disruptions and refusal to follow basic courtroom rules. This segment alone is a striking example of how a disregard for legal procedures can have real and immediate consequences, no matter how small the original issue may have seemed. The second case is equally compelling, though it unfolds over a much longer period and involves a much more complex dispute. This case centers on a woman named Rachel Langone, who is being sued by Midland Credit Management for an unpaid credit card debt from Children's Place. The total amount at stake is $643.63, a sum that is significant but not enormous. Yet what makes this case extraordinary is the legal strategy she adopts, which is highly unconventional and rooted in the sovereign citizen mindset. Instead of focusing on the standard defenses one might expect in a debt case, she takes a completely different approach. She argues that credit cards aren't real money. She questions the legitimacy of the financial system itself and challenges the right of the creditor to collect on the debt. She demands to see the original contract between herself and the original creditor, Community Bank, claiming that without this document, Midland Credit Management has no legal standing to pursue her. At the same time, she files a counterclaim for $3,744, seeking compensation for the time and effort she claims to have spent dealing with the lawsuit. Her arguments are based on a mix of legal theory and personal interpretation, designed to challenge the standard procedures of the court and assert her own understanding of the law. Throughout the hearing, the judge listens carefully. Every claim is considered, every argument noted. The courtroom tension grows as the discussion unfolds, with the judge trying to apply the law fairly while navigating a sea of unconventional claims. Yet the facts remain clear. Rachel has made payments to Midland Credit Management, and her arguments, while creative, fail to provide a legal basis to dismiss the debt. Her counterclaim is dismissed outright. The court explains that her demand to see the original contract does not negate the validity of the debt, and her interpretation that credit cards are not real money does not hold up under the law. In the end, the judge rules fully in favor of Midland Credit Management. The full amount owed, $643.63, must be paid. Watching these two cases side by side offers a fascinating insight into the mindsets of individuals who challenge the legal system. On one hand, a man treats a minor parking ticket as an opportunity to confront authority, ignoring courtroom rules and decorum. On the other, a woman takes a financial dispute as a platform to assert unconventional legal theories, hoping to redefine the rules entirely. Both encounters demonstrate the tension that arises when personal beliefs collide with established legal processes. What's particularly striking about these cases is not just the audacity of the defendants, but the patience and measured responses of the judges. In both instances, the judges attempt to maintain order and apply the law fairly, even in the face of repeated disruptions and unusual arguments. The courtroom is a place where rules exist for a reason, to ensure fairness, consistency, and respect for the process. When those rules are challenged, the results are rarely what the challenger expects. These cases also reveal how easily minor issues can escalate when individuals refuse to engage with the legal process in a standard way. A parking ticket can become a jail sentence. A small debt can turn into an elaborate courtroom drama with claims, counterclaims, and unusual defenses. They remind us that understanding and respecting the rules of the system is crucial, even when one feels wronged or disagrees with the process. Ultimately, these hearings are more than just legal disputes. They are lessons in human behavior, authority, and consequence. They show the fine line between challenging the system and disregarding it entirely, and the costs of crossing that line. For viewer, they provide both entertainment and insight, demonstrating how courtroom dynamics can shift dramatically based on behavior, argument, and adherence to procedure. These two cases, though different in their subject matter and complexity, share a common thread. They illustrate the limits of personal theories when faced with real-world legal procedures. They are reminders that the law, as rigid or formal as it may sometimes seem, is designed to function consistently, and that attempting to bend it to personal beliefs rarely succeeds. From minor infractions to financial disputes, the courtroom remains a place where respect, preparation, and understanding of the law make all the difference. Watching this video, it's impossible not to feel a mix of disbelief, curiosity, and even amusement. The human element, the stubbornness, creativity, and audacity, adds drama and tension to what are normally routine proceedings. Yet beneath the drama lies a clear message. Legal systems exist for a reason, and ignoring or challenging them without a strong foundation can lead to consequences far beyond what anyone expects. For anyone interested in law, human behavior, or just a dramatic glimpse into unusual courtroom interactions, this video offers an unforgettable experience. It's a deep dive into how ordinary legal issues can escalate, how people respond when they feel empowered to challenge authority, and how the legal system responds when confronted with unconventional tactics. From start to finish, these cases remind us that the courtroom is not just a place of rules, but a place where behavior, strategy, and respect all matter, and where the outcomes can be as surprising as they are instructive.
I 100% would not have disputed this with Midland, if that was the case, that I just wanted to borrow money and not pay it back. That's honestly,
Okay, so
that's not what it's
is your,
about.
I don't mean to cut you off, but I'm trying to follow. So your dispute is that, the past due debt was charged off? I'm not following what the dispute is.
My main, I feel like I need to, I obviously I didn't go to law school, so understanding this process is not easy for me. And if I lose the case, it's gonna be because of a procedural issue and my own fault, not because I'm wrong, though. I've learned way too much about the bank's process at this point. But
Well,
I just have to maintain that there's no contract.
I would disagree with that, because what you've said so far, was that you opened a credit card, that you used that credit card to purchase some things. And then you didn't pay the credit card. And I'm trying to understand, but you said that the credit card, it was paid, and I'm trying to figure out, how was it paid if you didn't pay it?
It's the banking process when I provide my social security number and did not fully understand what I was signing and what I was signing over.
Okay, so because you signed a contract for a credit card and you didn't fully understand, you think that that's a defense?
Well, see, that's the tricky thing is my defense would be different with Comenity versus Midland. So anytime
we're not talking about that. We're not talking about what hypothetically your defense would be with Comenity. This is Midland Credit Management versus Rachel Lamco.
So I'm maintaining that they don't have there's no contract to base any of the allegations in the papers that Midland has submitted. It's all based off of if there was a contract, and there is no contract.
There's no contract, you mean, between you and Midland Credit Union? Is that what you're saying?
Or
credit management?
Or myself in Comenity. Nobody has that contract.
No, I didn't ask you if anyone had the contract or anyone's produced it. I've already stated on the record that you signed a agreement with Comenity.
Right, but usually there's clauses in that agreement if they can legally sell my debt to a third party. So I would like to see that they could legally sell my debt to the third party.
Okay, so your defense was that you wanted to see evidence that they could legally sell the debt to Midland?
Yes.
Okay. Any other defenses?
No. Thank you.
Okay, and then you filed a counter suit.
Yeah, that was for my time doing
For your time?
Yeah.
What do you mean for your time?
For responding and getting this suit that I don't agree with, and I figured if the attorney could get paid for their time, then I could get paid for mine.
Do you believe that you should get paid $3,744 for your time? Your counterclaim is dismissed. It's not properly pled. You've not provided any basis upon which the court can grant you $3,744 for responding to a lawsuit, which I'm going to cut to the chase. It's very clear to me that you have opened up a credit card and you failed to pay the debt. Now, whether or not Comenity had the right to sell or transfer your debt to another entity, which is common in when you open up a credit card, that's unknown. Did you provide that information for her, Ms. Smith? We can't hear you. You might be muted.
Sorry, I did mute myself because I had to cough. I don't believe so, other than the letter sent by Comenity to her indicating that the account had been sold and Midland now owns it and was able to exercise full rights to collect on it. That was sent to her back in December. excuse me, of 2021. And that was included as part of the documents attached to our motion. And then again,
Okay.
I would also emphasize that there was a payment plan made with Midland as well, so.
She made a payment plan with Midland?
Yes, there were two $15 payments made, to the account.
When?
This was, give me a moment, Your Honor, it's in the motion. They were made, there was one payment for $15 made August 28th of 2022. That payment was actually returned on August 31st of 2022. And then there was another $15 payment was made October 27th of 22.
Why was the August 22 payment returned?
My system says declined. I'm not sure if, I mean, that could be, like if a credit or debit card was used and then it ended up being, you know, like an invalid account number, or like the account got closed, or it could be an NSF.
Okay, but the October 27, 2022 payment was accepted?
That's correct, Your Honor.
Okay, so Ms. Langone, you've actually waived any defense or argument that you had that you didn't have a debt or a duty to pay the debt. You tried to make payments on the debt with Midland, not with.
Before I knew my rights.
That you've waived that argument. Even if they were to provide you a physical copy of the agreement, which I don't know how you applied for this credit card. I don't know if you applied in a store. I don't know if you applied online. You're not disputing that you applied. You're just disputing that there may possibly have been a clause in there that would be a defense for you. But you have not been able to produce any of that on your own. You've produced nothing to the court. To the contrary, you've produced information through your answer and even in your responses today that tend to lead to the fact that you owe this money. You have no plausible defense to the debt. I'm finding judgment in favor of the plaintiff.